Good morning, everyone. This is David. Brian Watts, my law partner, and I are on a mission. Our mission is to stop contract derailments. You know, those are the objections that weren't the real reason they terminated the contract. Some people call them loopholes. That's what the people who approach me at cocktail parties want to find out about. You know, most of you know, when I go to a cocktail party, people come up to me and they never ask me what I think about the Texas Rangers or the Dallas Mavericks or the Dallas Cowboys. Instead, they say, "You're a lawyer, let me ask you a question." And it always is about the house that they no longer love, that they're contracted to buy. Almost always they say, "And by the way, tomorrow is the closing date." And then they follow that. Some of them say, "And if I just don't close at all, will I lose my earnest money?" And you know, you just want to say, "Are you crazy? You're going to lose your earnest money." But that's not the right answer. The right answer is, among other things, you may lose the earnest money. You could also be sued for damages or specific performance or both. So today we're going to highlight how and when you plug loopholes, hopefully before they ever become a loophole and get used to derail the contract. We're going to talk mainly about three sources of loopholes: the people, the money, and the property. These three categories all originate with the TREC 1-4 family contract or with one of the various addenda. Hopefully you have a copy of the 1-4 family contract with you so that we can point out some things, and it works better that way. So let's start with the people. All of us know that the vast majority of people signing contracts who are either buyers or sellers are perfectly normal. But things can happen. Unfortunately, they can die, they can become legally incompetent, or bankrupt, divorced, or even get married, or incur judgments against themselves or their property. Or they can simply refuse to close, like my cocktail party illustration. So Brian Watts is going to talk about the people in the transactions. Brian?
Thanks, David. You know, sometimes people try to make contracts a lot more complicated than they are. And there's some simple things that are just fundamental about every contract. You have to have the right people involved, you have to have the sales price, and you have to be able to identify what the property is. And those three things probably cover 90 to 95% of any issue that we have in a transaction. David and I are in a unique position. We have a great job because most of the day we spend just talking to real estate agents. They don't call us on the deals that are fine. They don't call us about the deal. They never call us to tell us that a deal has closed and there were absolutely no issues whatsoever and everything went smoothly. We get the calls. They want to talk to us when there's an issue involved. And one of the fundamental issues always revolves around, do you have the proper parties in the contract? Are the proper parties at the closing table getting ready to close the transaction? So if I were to tell you the most important thing that you could do in making sure that you don't have a contract derailment is to start as early as possible. From personal experience, if there's going to be an issue, the more time you have to resolve the issue, the better you're going to be able to have a successful closing. So I am always going to recommend to people they start thinking about this issue of, do we have the proper parties involved, the first meeting that they have with their client, either as a seller or as a buyer. You want to be sure when you first meet with your client, you are able to identify exactly what is going on and whether you're going to have any sort of issues. So with the seller, that's going to be the listing appointment. And the first thing I'm going to tell you to do when you meet with a client is to give them their homework that they have to do to help you do your job. You want to get a copy of the existing deed where they acquired the property. If possible, you'd like to get a copy of their title policy when they acquired the property and copies of their loan papers, that you can look at that and identify who you think ought to be the owners of the property and who ought to be the sellers of the property. Those would be the people that sign your listing agreement. Now, in most instances, everything's fine. They bought the property when they were married, and now they're selling the property. There's not been any change in circumstances, and so it's going to run smoothly. But there are situations where you need to be able to identify what issues there might be. For example, if you only have one owner of the property and they are married, are we going to need their spouse to sign? Has a former owner of the property died? Has the property been placed into a trust? Is the seller a United States citizen with proper identification that they're going to be able to sign documents and a notary is going to be able to notarize their signature? And will you need to possibly have to withhold 10% of the gross sales price because they are not a United States citizen? Will you be using a power of attorney because one of the owners of the property is going to be out of town? If so, do you need to get that to the title company so that they can look at the power of attorney or get the title company to prepare a power of attorney and have it signed, notarized, and back to the title company by the time of closing? Last example, has the client filed for bankruptcy? That might possibly involve a bankruptcy trustee and getting court authority to have to sell the property. So that's the listing appointment. At the listing appointment, you have to ask those questions. On the contract point, you want to be sure that all the owners sign the contract. Everybody who's going to have to be committed to sell the property is going to want to be a party to that. If there is a power of attorney, get a copy of that power of attorney and make sure that the person signing the contract on behalf of somebody else truly is authorized to do so. Now, what is the next step in the process that's important? And that's going to be when you get the title commitment from the title company. This is a gold mine, and it contains information that you need to look at. I can't tell you how many people get the title commitment and agents think it doesn't involve them. It does involve them. This is a document that provides valuable information, and it is incumbent upon you to look at that title commitment as soon as possible. Schedule A of the title commitment has a notation of who the record owners are. That's important. What if there's somebody listed as a record owner that you did not know about? Perhaps they didn't tell you that they were previously married to somebody, but that person had died, and they didn't go to the trouble of having a will probated, and they didn't do what was necessary to change the record title. And as far as the title company is concerned, there are two people that need to sign the closing documents, and you only have one person as your seller. So always look at Schedule A to see if there are any names out there that you were not aware of that you need to be concerned about. That gives you information, and it also hopefully gives you information enough time before closing that you can address those issues with the title company so that you'll have a smooth closing and you won't have that contract derailment. The other part of the title commitment that's relevant with respect to the parties is Schedule C. Are there other requirements that the title company has imposed? And we'll go over some of those. But Schedule C gives you information of things that may need to be accomplished at or before closing, that the more time you have to resolve the issue, the better it is for you to do that. An important example that we come across often is where one person owns the property as their sole and separate property, but they are married. Or a buyer is going to purchase property and they're married but they're planning to get divorced. And so there's a spouse involved that who's not entitled or will not be entitled. And that is something that a lot of people don't understand. It can be absolutely relevant. On the seller side, a lot of times a seller will come in and say, we have a marital property agreement, and this is my separate property. Or I acquired this property before I got married, and this is my separate property, and so my spouse does not need to sign. Legally, I can understand what they're saying, but it is incorrect. There's another issue if this is the homestead. The Texas Constitution and the Texas Family Code are very clear. Even if property is the separate property of one of the spouses, if it's homestead, the other spouse must join in the conveyance. And therefore, that spouse who owns no community property interest in the property still has a homestead interest. And under the Texas Constitution since the 19th century, it has been a requirement that that spouse be involved in the closing process, and the title company will typically require that spouse to join in the deed. Therefore, it may be appropriate at either at both the listing agreement and the contract agreement that you get something in writing from that spouse saying that even though I do not own an interest in the property, and I am not and will not be a seller in this transaction, I agree to sign those documents necessary to be able to accomplish the transaction. In addition, it may be appropriate for that spouse to acknowledge that the property is their spouse's separate property and all proceeds are to be payable to that spouse. On the buyer side, likewise, the Constitution will require that before you can put a lien against the property, the spouse must join in the deed of trust. Now, there may be some exceptions to that, and I don't want to paint with too broad of a brush, but a lot of lenders, many lenders, will require that spouse always to sign the deed of trust. So, you as a buyer want to be sure that your spouse will be willing to sign the deed of trust, and you might want to get that in writing when you sign up the contract. Another area that is relevant to us is when you have a deceased owner. You need to be able to get with the title company as soon as possible. Important things that we need to know. When did they die? Was there a will? Has that will been probated, or has an administration been opened? One of the things that is most difficult to deal with is when somebody dies very recently, and one of the first things the heirs do after the funeral is they want to put the property on the market as soon as possible and wrap things up as soon as possible. That's premature, and that can be very dangerous. I would always recommend that you do not rush a sale. If a person is recently deceased, they should always consult with a probate attorney immediately to be sure they know what may be necessary. I can't go into all the details because each case is different, but if there's a will, a decision has to be made whether there are assets in that estate that will require the will to be probated. Probate is not something to be afraid of. It's really can be a fairly simple process in most cases. And so consulting with an attorney immediately to see if it's necessary to probate the case, and usually within 2 or 3 weeks a probate attorney can get an executor appointed. The executor will have the power to sell the real property, and a closing can proceed smoothly. But if you don't do that at the front end, when you get the listing, you may run out of time, and you might not be able to close on time if you haven't started the process as soon as possible. Again, I'm going to say, time is something that is very valuable in these situations. You want to be able to get going as soon as possible to make sure you have the right parties involved. Talk to your attorney immediately. Talk to the title company immediately. The next issue that is relevant is when you have divorcing sellers. There are 2 issues. One, are they going to be signing the closing documents? And second, even if they all agree to sign the closing documents, how are they going to be dispersing the proceeds from the sale? That can be absolutely crucial in many of these situations, because although the sellers may be in agreement that they're going to sell the house and they want to get it sold, then they start arguing over how they're going to disperse the proceeds. And I'm telling you right now, that can be a bigger problem than the first issue of signing the documents, is who gets the money. And the title company is going to insist that this be done, that the proceeds be, the disbursement of the proceeds be agreed upon as soon as possible. On the flip side, you have divorcing buyers. They often rush the process. And it is crucial that they talk to their divorce attorney before they enter into any contract to buy a property. I can't tell you how many times, and David, you can chime in on this, that the attorney, the divorce attorney, chuckles when we call them up for information, and they say, I didn't know that my client was buying a property. The divorce attorney is sometimes the last to know. And it's very important, because sometimes there's a temporary injunction prohibiting the spouses from entering into a contract such as this. Or the other spouse may need to sign the deed of trust so that they can get the loan. And finally, it's very, very important that since any property acquired during the marriage is presumed to be community property, you need to have a separate agreement between the husband and the wife who are divorcing, where they agree as to what the character of this property will be. Will it be the purchasing buyer's sole and separate property? That's something where the divorce attorney needs to get involved. So therefore, in these situations, that joinder of spouse agreement that we talked about can be very important on the seller side and on the buyer side. And on the seller side, you want to have one of those agreements perhaps during the listing agreement, where the spouse agrees that they'll sign documents, and with the contract. And if you are on the other side of a contract where there may be an issue, you want to be sure of this as well.
And you don't want to prepare those kinds of documents yourself. You want to get help on that. We don't want anyone trying to practice law without a license and getting in trouble for it.
Absolutely. And David and I have done this a lot before. And contact your title company or the lawyers of the parties, and they should be able to help with this. Other things where the client may be unique may involve trust agreements, powers of attorney. You want to be sure you have the original power of attorney. Partnerships and corporations. You want to have documentation showing that those entities exist, that they are authorized to enter into those transactions, and the person's authorized to sign. We've gone over executors of estates, heirs without a probate. Guardianships are important as well. You may have an owner who is mentally incompetent or is a minor. These are very, very important transactions, in that you must have a lawyer involved. If there's a guardianship, the general rule is you cannot sell real property unless you go through a specific procedure through the probate courts authorizing the guardian to sell the property, and specifically authorizing the contract that you are going to sign. And the last thing that I'm going to talk about in the parties section is to warn you about people that like to name the buyer as Joe Smith and or assigns. I know that this has been going on for years and years and years. I think we had a whole lot of it back in the 1970s and the 1980s when people were blowing and going and doing all sorts of crazy real estate deals in the go-go days, and they would put in and or assigns as the name of the buyer. The concern I have with that is that's not the proper place to put it in the contract. If you want to say that the contract is assignable, you can go ahead and put that maybe in paragraph 11. But the contract where the name of the buyer is identified, you need to have a specific buyer identified. The buyer is Joe Smith, not Joe Smith and or assigns, because then it is vague and ambiguous as to who the buyer is. Perhaps Joe Smith will go down to Skid Row the day after the contract is signed and assign it to somebody. Do you want that person to be the named buyer in your contract? I don't think you do. And so you as the buyer you as the seller want to insist that you have a specific person identified as the liable party, because let's say the contract goes into default. The buyer doesn't perform. You want to go sue Joe Smith. And you write Joe Smith a demand letter, and Joe Smith says, oh, I used to be the buyer under the contract, but the contract buyer is Joe Smith or assigns, and I assigned it, and so therefore I am not the buyer under the contract anymore, and I don't have liability. I think that's not a fair situation. In any event, if you are contemplating that there may be an assignment of the contract, as a seller, you want to be sure that you have somebody that you have recourse against. You either want to put restrictions on who the contract could be assigned to, or if it's contemplated that there may be an assignment, you want to be sure there's plenty of earnest money at the title company so that you have recourse against something. And when there's money in the title company, that's going to probably give the seller their best level of protection.
And you want to get somebody to help you with that as well. This, once again, don't try to rely on drafting things like that. Just get help. Understand the words that we're talking about, but don't try to write them.
There you go. And this is what David and I do each and every day. And the reason I enjoy getting up every morning. And the bottom line is, you want to be sure that your client can perform. You want to be sure that the other side can perform. And you want to know that if the deal falls apart, your client has someone to sue. Making sure that you have the proper parties is absolutely essential.
Wow, Brian, where is Skid Row anyway? I've always wondered where that was. I think I may be sitting on it. Anyway, we're going to talk next about the money in the transaction. And as a title company, we deal with earnest money, we deal with option money, down payment money, lender's money, and daddy's money. And naturally, the one source that creates the most loopholes is the lender's money. You and I, about 20 years ago in our industry, created a new term. It was called the pre-approved. And it always is in a sentence that's kind of a proud-sounding sentence. My client is pre-approved. Well, when that came out, the broker-lawyer committee only had one contingency for financing. It was a catch-all for everything in the promulgated form. And they reasoned that if the buyer was pre-approved, then they didn't need that part about the buyer's credit to be a contingency anymore. So they took the financing contingency and split it into two. One dealing with the buyer's credit, which is the third-party financing addendum for the buyer's credit approval, and one dealing with the approval of the seller's property. The third-party financing addendum, as you know, is an addendum that's attached and referenced in paragraph 4. And the property approval, the seller's property approval, is in paragraph 4A1. Probably the biggest difference between those two contingencies is that the credit approval has a time limit that you insert in the blank in the addendum. By the way, listing agents don't fail to insert a number. I saw one last week where there was no number. That means they've got until closing to get their credit approval. The property approval, on the other hand, has no time limit. And I really worried about that when it first came out, but it really hasn't been abused very much. The danger, though, is when you extend the closing date. The time limit that has no limit, or the property approval that has no time limit is extended automatically with the extension of the closing date. Something needs to be done. We'll talk about that in a minute. Remember that the seller's property approval is about three things. The appraisal, the lender's appraisal, bear that in mind, the lender's appraisal, the insurability of the property, and the lender required repairs. Don't forget that the appraisal required by the lender may not require the property to be appraised for the sales price. So if you have a buyer who wants the appraisal to show that the property is by golly worth what they paid for it, then they need to have a separate contingency written. A classic example, let's say somebody's buying a $600,000 house and they're paying $300,000 in cash. They're borrowing $300,000 cash. If they get an appraisal, not of $600,000 but say $550,000, the loan could conceivably still be approved because the lender is satisfied with their underwriting requirements. Remember that on this contingency. And one last point about the money, and that is the lending industry has changed dramatically. I know everybody knows that in the last few years. And escrows for repairs are not very popular in the mortgage lending industry right now. So beware of trying to get, we had the hail damage, we had all those repairs, and yet we had lots of closings postponed because the lenders were not agreeable to allowing the balance of the repairs to be held in escrow. Okay, so let's talk about the next derailment loophole, and that's the property. And I just want to make a comment about the correct property description, and that is, I saw a contract a couple of weeks ago where the property was Lot 1 and part of Lot 2 in Block A of the subdivision. What part of Lot 2 were they talking about? They were not. That's a loophole that will get you thrown out of a contract really fast. So my rule is that I use the DCAD for lot and block only, and it can be, if it specifies what part of the lot, you can use it for that as well. But if you have anything other than a lot and block, I think you need to go to the seller's deed or their title policy. It's very easy to find in their title policy and copy in the contract what their legal description is. Next, I want to talk about page 2 of the contract. Now, page 2, I wrote part of that when I was on the broker lawyer committee, and I got to tell you, this is the most boring page in the contract, and I think I'm probably responsible. I apologize for that. But before we get to it, hold your finger on page 2 and turn to page 5, and I want to talk about the conversation between the seller and the buyer. They have this conversation. It's actually in writing in the contract, but it's a conversation. They have several of them. They have one about money and sales price and financing, and this one is about the property. And the thing we have to all remember is that when the buyer acquires the property, signs the contract to acquire the property, they don't have a clue what's going on with the title. So here's what's going on with the title. If you look on page 5, paragraph 9B1 is the provision that requires the seller to execute a general warranty deed to the buyer at closing, showing no additional exceptions to those permitted in paragraph 6. Okay, so it's a warranty deed with some permitted title exceptions. Now look back at paragraph 6 on page 2, 6A, mark that vertical list of 1, 2, 3, 4, 5, 6, 7, 8, and write 3 words beside that. Write the words permitted title exceptions. That's what they are. The seller is saying, I'm going to deliver you title to the property minus these 8 things with the exception that's provided below. And put an asterisk, in addition to the bracket naming all of these, put an asterisk by number 1 and number 4. They're the ones that are going to cause you the most issues in the negotiations. Now, I've got a little drawing here, and that's kind of the best I can do.
Now there is an important legal document, David. I just want to compliment you.
Thank you for that. Thank you for that. That's what the seller is signing the warranty deed to. It's actually not a two-dimensional object, though, because the boundaries, as you can see on the lot, actually go down like a cylinder and go to the center of the earth, and they go from there, from the surface, they go up and out to the heavens. So that's what they are now. We'll show this next slide shows just a couple of permitted title exceptions that I just made up here and put on there. The green hash line that intersects and it says setback lines. That's where the building can be and cannot go across those lines. And this particular drawing is right on the setback lines, and so it can't be expanded. You got the ugly green box in the back right-hand side. That's that electrical deal. Don't lick your finger and put it on that box. And then the subdivision sewer line going across the rear left side. Now, the buyer in paragraph B of the contract is going to get three things. They're going to get the title commitment. In paragraph 6B, it's the second line down. It says commitment for title insurance, and then it's a defined term called commitment right there beside it. Underline those. And then two more lines down in the same paragraph, the exception documents. Those are the deed restrictions and any bylaws and rules and things of that nature that you see. And then finally, the third thing that's delivered to them is the survey in paragraph C, and you all know what those distinctions are. Then the issue really is, how does the buyer protect themselves from constructing or installing future improvements on the property when they really don't know where things are? Remember, they're signing the contract not knowing where things are. And so those two blank lines there in paragraph 6D are not for people to write just the words single family use. Now look at the next slide, and I'll show you what you do. Everyone should ask your buyer, everyone who's a selling agent for the buyer, should ask the buyer before you complete the contract on these two blank lines. Do you plan, Mr. and Mrs. Buyer, do you plan now or at any time in the future to add to or change the exterior of the property? And whatever they tell you, you write on this line. And usually the words start with the installation of or the construction of. So for example, now you can see in red the things that this couple wants to do. They want to install a pool. They want to construct a storage facility around the ugly green box. And they want to add on to their family and their house out beyond the setback lines. Well, they can't do any of those because those are permitted title exceptions that they can't violate, except if they write those words. So if they say single family use in there, they won't be able to get out of the contract. Conversely, if they do write the things, the installation of a pool and so on, then if those things, read the language right before the lines, which prohibit the following use or activity. Those are the things they can object to from the permitted title exceptions.
And I might add too, your buyer usually at the contract stage doesn't know exactly what they're going to do. We know we'd like to build a pool somewhere, and so you want, if you're representing the buyer, you want to give your buyer some flexibility and perhaps say a pool in a location and with dimensions acceptable to buyer. And that will give the buyer some more flexibility once they've seen their survey.
Exactly. Now, one final point on this boring page, and that is down at the bottom, right below those two blank lines, is 6D2I. And that's the amount of time that the buyer has in which to object once they've found that they can't build the pool. Once they found that they can't build the pool where they wanted to and those other buildings where they wanted to. And so they insert, most people put 3 or 5. I put 3 for closings every month except November and December, and I put 5 days for November and December because they're potentially 2 4-day holidays. And so here's how you calculate the time, though. After the buyer receives the last of those 3 things that we just named, the commitment, the exception documents, and the survey, that's day 0 on this number of days that you've inserted. The next day is miraculously day 1. Now, more important on our subject of preventing loopholes and derailment is what the listing agent is doing about these same items that were drawn on the drawing there, the electrical box and the sewer line and the setbacks. If there are any other items like those that the seller should tell the buyer about. For example, in Lakewood, East Dallas, they've got a lot of shared driveways. Well, I got to tell you what those shared driveways are. If your neighbor is using 5 feet of your property, that's an easement that is not a permitted title exception. And that is a grand way to escape the contract on the part of the buyer. Similar issues are boundary problems, where the classic brick wall that's on the eastern boundary of the property, and it triangulates, as they say, off of the property to the back corner and is trespassing on the next door neighbor. Those are all outs for buyers. And if you, as a listing agent, are doing what Brian said earlier and looking at the title policy, then you can find those references. That's in Schedule B. Those are the permanent title exceptions that you can usually find in there. Okay, Brian, you get to talk about the remaining
Some more property issues with loophole significance. You know, sometimes people are their own worst enemies, and they do things or they don't do things that create the loophole for the other guy. One of the key things is failure to give the other party documents that you're required to give, and that results in the other side having the right to get out of the property, get out of the contract. They have an escape hatch. For example, the homeowners association addendum and the condominium resale certificate requirements require that the seller get those resale certificates and subdivision information to the buyer within a specified time. If you don't, then they may have a right to terminate the contract. And then, when you do give it to them, they have a specified amount of time during which they have an unrestricted right to terminate the contract. It's as if they have a whole nother unrestricted right to terminate under paragraph 23 built into the contract because you failed to give them the resale certificate subdivision information that they were entitled to receive. Likewise, the seller's disclosure notice. There's no reason for a listing agent not to be able to give the seller's disclosure notice to the prospective buyer before any contract is signed. Under paragraph 7, if you fail to do that, you have given them automatically a 7-day right to get out of the contract that starts on the day that you get them the seller's disclosure notice. So don't fail to give them information that would let them off the hook. Also, don't give the other side excuses not to perform. I've seen situations where you have a seller and buyer who are angry at each other, and the seller thinks that he's going to get a leg up on the buyer, and he says, "I'm not going to give you access to the property." Well, you know, he's being macho there, and he's showing that he doesn't have to let the buyer onto the property. But he's probably breaching the contract under paragraph 7 that requires him to provide access at reasonable times. He's given the buyer an escape hatch, and maybe the buyer wants out of the contract and the seller doesn't want to, but he's shooting himself in the foot. The seller doesn't vacate before the closing date, and possession is to be delivered at closing and funding. The seller may have personal reasons why he thinks he's justified or it's legitimate for him to do that, but he has to understand that if he does that, he's giving the buyer a reason not to perform. The last thing is the seller removes fixtures. He removes the chandelier from the dining room. The buyer does the walkthrough and discovers that, and the buyer was looking for a reason to get out of the contract, and the seller again shot himself in the foot because he removed something from the property he wasn't supposed to, and therefore the buyer has a way out of the contract. And the last thing I'd talk about here is beware of the contingency without a deadline. This is most significant when you write something in yourself into paragraph 11. You've gone outside the safe room of the promulgated form prepared by the Trek Lawyer Broker Commission, and now you are making up your own words. One of the biggest things that I see is somebody creates a contingency and it doesn't have a deadline, and the seller allows that to happen, and therefore the buyer has an out until closing. Buyer may terminate the contract if the property does not appraise for at least the sales price. That could give the buyer an out all the way up to the closing table, and the buyer can elect not to close the transaction at the closing table, and he either may elect not to close the transaction, or he may exact concessions out of the seller who's at the closing table and has to get that property signed. So that is something that if you are preparing special provisions of any complexity, consult with a professional that has experience drafting those sorts of provisions, and they can help you. So let's review the process of eliminating the loopholes in contracts. First, you have to have the right people named. Everyone has to sign, or they ought to sign one of those joinders that David and I talked about. You have to have the correct property description inserted into the contract. You got to fill in the critical dates everywhere in the contract. One of the last things you do is you proof your work. You'll go over everything and make sure you filled in every blank. You checked every box. And when you fill in blank dates, make sure those dates work and they're consistent with each other. And then lastly, as David talked about, look at those permitted title exceptions in Schedule B. Are they permitted under the contract? If they're not, you need to deal with them in some fashion so that you're going to be able to get the deal closed.
Okay, thank you, Brian. And let's now talk about review the number one source of contrived terminations. It's extending the closing date with an amendment to the contract. That's just an accident looking for a place to happen. And there are 5 topics here that involve more documents than that. But we'll start with the first one. You know, we have all this discussion about the time limit for the buyer's credit approval on their third-party financing condition addendum. Make sure that has passed. Get help getting this document written, by the way. I always add some language to the amendment, and in this one I almost always use a self-serving statement that the buyer's credit approval deadline in the third-party financing condition addendum has expired and is no longer in existence. Next, the dangerous one that I said earlier, number 2 there in your list. The buyer has no time limit on their lender's underwriting requirements, the satisfaction of the lender's underwriting requirements for those 3 reasons: appraisal, insurability, and property condition. And so when they get the last of the 3, you need to know that's when their time exists. And unfortunately for us, a lot of times the survey comes in the day before closing and they've got 3 or 5 days to object. That automatically puts it in there. And so I always have the lender's underwriting requirement waived before entering into an extension of the closing date. Then you get those 3 title documents in number 3. You get the on that page 2 that we talked about, the title insurance commitment, the exception documents, and the survey. So make sure that those are taken care of, and that the right to object has expired. And I sometimes say that as well when I'm doing one of these. The new HOA addendum went from a 7-day period to terminate to a 3-day period following the receipt of the documents from the HOA. And so the date actually runs from the date they got the subdivision information. If that's the day before the amendment extending the closing date, then they've got a 3-day right, and 2 of them are in the extension. So beware of that. And finally, this doesn't happen very often, but if lead-based paint is involved, it's got a rescission right as well, and it should be waived unless it has clearly expired. Now what we'll do is we'll take questions, and we'll try to summarize or read the questions. They're in this microscopic type that Brian Watts is going to have to read out loud, because he has better eyes than I do. You want to just start with those?
Start at the top. First question. This is a great question. We get this one all the time. If your buyer wants contingency, the property must appraise for purchase price. Where does that language get inserted? Well, the first thing I'd say is you certainly have a qualified appraisal contingency already contained in paragraph 4A1. If the property does not meet the lender's underwriting requirements, and part of that is the lender's appraisal. I suggest that this, if you're going to draft a certain special clause, obviously it goes in paragraph 11. I will suggest that you have language that has been prepared for you by an attorney. I'm not a big fan of these clauses in the first place. I think there's a justification if it could affect the buyer's right to get financing. I'd love to see a listing agent respond to a buyer sometime and say, okay, well, can I have a clause that says if the property appraises for more than the sales price, the seller can terminate the contract? I think a buyer with one of these clauses sometimes is trying to protect themselves from making their own bad decision. But if you agree to a clause like this, I think as a seller you're going to want to insist on things such as how is the appraisal determined, the appraised value determined, who is the appraiser, when is the appraisal going to be done, and make sure that the seller is furnished with a copy of the appraisal so they can verify whether the property has or has not appraised. David?
I agree with that. The next question is,
Actually, this was a question regarding DCAT and how inaccurate the records are, and we thought you answered it, but this person, Beverly, would like more information on the legal description. You mentioned that in DCAT.
Oh, to show ownership?
Right.
Yeah, the thing you have to understand is DCAD is putting in the appraisal district records who they believe the owner is, and that is for their purposes, for purposes of tax assessments. Usually it's correct. If somebody asks me who owns a piece of property and I'm just on the phone with them and I don't have our title plant to go back to and delve into on that phone call, I'll go to DCAD and look and see who they say it is. That is a good starting point. All I'm saying is it is only a starting point, and you need to be able to verify that it is correct, because sometimes they don't have things correct. They don't know that there's been a deceased person. They don't know that there has been a divorce. A lot of times people get divorced and the property is awarded to one of the spouses, but they fail to get a deed from the one ex-spouse to the spouse who was awarded the property. And so there's nothing in the deed records for DCAD to catch. And so their records are necessarily incomplete. DCAD records are an excellent starting point. I use them, but it's only a starting point.
And this question is, with a single-family residence in an HOA, which HOA documents do you need to provide? That's the so-called subdivision information. That's a defined term in the new HOA addendum. And subdivision information is defined as a current copy of the restrictions and bylaws and rules of the association, plus a resale certificate, which is also promulgated by TREC. Those are the things that need to be provided every time. Next question. Can a listing agent deny access to the property on the day of closing to perform a final walkthrough? Answer is absolutely not, unless it is for some reason unreasonable. The paragraph 7 that Brian Watts talked about a little while ago was actually designed to work with the timing of the closing. It was presumed that everyone was going to do a walkthrough before closing. Not everyone does, but everyone probably should. It would save a lot of heartache later from things that are missing and so on. Brian, you want to do this one?
If the seller have a property before he got married, the homestead person get part of the sales proceeds if they want. So in other words, if I guess the question is, if the property is the separate property of one of the spouses, can they sell the property and the other spouse receive a part of the sales proceeds? Generally speaking, proceeds from the sale of separate property remain the separate property of the person who owns the property being sold. So the other spouse does not have an interest in the proceeds. Now, could those spouses agree between themselves? I suppose they could, and I would think that if there was a disagreement on that point, perhaps that marriage is not long for this world.
Yeah, and the thing is, don't confuse separate property and community property rules with the homestead rule. Homestead has nothing to do with the ownership. It's simply the right to possess and to live there. And so it doesn't change when someone is a widower or a single person that owns a piece of property before they get married. The fact that they get married simply confers a homestead right in the spouse. It doesn't necessarily confer ownership. Brian, they've got your and/or assigns.
And/or assigns. What specific wording would you recommend to be put in paragraph 11 of the contract? Well, first of all, you don't necessarily have to have any wording. Because a contract, unless it is specific to a person, a contract is generally assignable. Although, if there were seller financing involved, I think that is personal to the particular buyer, and they probably need to get consent. It's not bad to put a clause in. Buyer may assign this contract. The seller might want to add language to any party that is creditworthy in seller's reasonable opinion, not to be reasonable consent, not to be unreasonably withheld. It also is important to remember that when you assign a contract, that does not release you of liability from the contract. So if John Smith is the buyer and he assigns the property to the contract to a third party, John Smith is still on the hook and is still liable.
There's a probate question there for you.
Does the property and probate need to have a final decree prior to selling? You, depending upon the type of probate it is, you have to have a decree admitting the will to probate and appointing the executor if there's going to be an executor. And then usually an executor has power of sale. Each case is different. I hate to be too detailed about that one.
Here's a question about the seller's disclosure notice. If it's on the MLS listing, does this satisfy delivery? What do you think, Brian? We'll probably have an argument on this one.
I think the key is what do you check in the contracts? If you check 7B1 in the contract stating that buyer has received the notice, then the buyer has acknowledged that they've received the notice. I think that's sufficient.
Otherwise, probably not.
See, we don't have arguments.
Okay.
We agree on everything.
All right. You're right.
This is a long one.
A man passed away who owned a number of properties. Some of the properties were in his name and his deceased wife's name. Wife died 12 years ago, was never taken off the deed. Her estate was never probated. How is her name removed from the deed so that the newly created estate of the husband can either sell these properties to an outside party or convey it without compensation to an individual family member? Wow. I think this question proved my point. You want to ask detailed questions and get to a professional as soon as possible. There are a whole lot of different possibilities in this one. It depends upon the facts. A cursory look at this could be that they would go to the title company and ask the title company if they could do what's known as an affidavit of heirship. The title company would get information from the parties to be able to evaluate who the property would have gone, who the wife's interest in the property would have gone to, and then put evidence in the record. If it's too complex and you can't do that, then that would if you can't do that, then that's going to maybe require that you go to a probate action.
Also, I want to make a comment about her name. The deceased lady's name is never removed from the deed. Deeds are, once they're recorded, they're never changed. And so when someone dies, their name, people don't go back and remove their name from it. You file something else that explains why they're no longer the owner.
Mm-hmm.
Okay, we're about out of time. We're going to continue with.
You can continue.
We'll continue with a few more and then adjourn. Those of you who need to hang up, thank you for joining us. Brian, you want to read that? I can't.
Can you put a deadline for the appraisal to be completed?
Absolutely.
Absolutely. If you're a seller that you don't want there to be a surprise at the closing table.
You always want a deadline.
And we'll point out, paragraph 4A1 does not contain a deadline. So that might be grounds for a seller wanting a special provision in paragraph 11 to address. And we've sometimes been asked to do that.
That's correct.
Can a divorced seller hold up funding of a buyer's loan because of a disagreement over disbursement of proceeds?
I think that seller is asking for a lot of trouble. I think they're creating a loophole. They're basically, because if they can't agree between themselves as to who gets the total proceeds, the buyer has closed or has tendered performance, presented all of the funds. And if the sellers can't agree upon it and won't give the buyer the deed and maybe more importantly the possession to the property, I think the seller is going to be in a position of default.
Great. Earnest money pertains to the buyer losing. What does the seller lose if he's the one that doesn't want to close because the seller changed their mind?
Well, remember, it isn't the seller's money, so the buyer would simply get back their money, but they do have two other remedies. And if this happens at the very 11th hour, that seller may be more of a candidate for a specific performance lawsuit compelling their performance. And then if you win that, you can later file an amendment in your lawsuit for damages. And so that's probably the route that would be taken in that one.
What if items are listed as excluded, like a light fixture that may have been a gift? How does that work, or does that cause any loopholes? That certainly is a concern that the parties don't have an understanding of what goes with the property, what's included and what is not included. And you have to check whether the item that you think is to be excluded is properly identified in paragraph 2. Is it part of the property that is included in the property under the definition of paragraph 2? And is it excluded under paragraph 2D? Okay,
the next question is how do you handle the appraisal coming in too low? You just have a problem. You go, everybody tries to influence the appraiser, and I think that's a pretty difficult task these days. So I think you're just going to fail on that one. Read that.
Question. Recently had a deal fall apart because the property had been acquired through an HOA foreclosure, and the title company would not provide title insurance. Can you provide info on this?
That's that right of redemption that exists when an HOA forecloses, depending on the nature of the property that was foreclosed, whether it's a condo or a single-family detached. The former owner has the right to go back in and redeem the property by paying an amount plus interest to the HOA.
Yeah, and I tell people to be careful of these. I don't want to speak with generalities and say that these are bad deals or wrong deals or anything like that. However, this is like that situation where that person serving the United States military got his home foreclosed a few years ago, and there was a big court battle, and the parties are very, very careful. Title companies are very worried about these sorts of transactions. They're going to look at them with a fine-tooth comb. There are some title companies that just won't get involved with properties that were acquired at a homeowner association foreclosure, so be very wary of getting into these sorts of transactions.
I agree, and that completes our list of questions. We thank you for attending and hope to see you soon.